I'll start off with our first question, which is for Prabha. I know some of the work you've done is in the human rights space. What are the most important human rights, and what is at stake for us?
We're sharing today. Thanks very much, Candice, and thank you enormously, Manal, for this very generous invitation to come speak here today. It's truly an honour. Before I start, I'd like to acknowledge that I'm here on unceded Gadigal land, and I pay my deepest respects to their elders, past, present, emerging, and extend that respect to any First Nations colleagues joining us today. I want to take a step back and firstly talk about what human rights are and how they are or how they aren't protected in Australia. So human rights is a term that's thrown around a lot. At its core, they recognise the inherent value and dignity of human beings, regardless of our race, ethnicity, where we live, or gender. Human rights are so important because they are about being treated fairly without discrimination. It's about treating others fairly, and it's about the ability to make genuine choices in our everyday life. Now, it's the 1948 UN Declaration on Human Rights. That's the foundational document that sets out our basic rights and freedoms. Now, Australia is really good at signing up to international human rights treaties. We have signed up to the 7 core documents that outline our civil and political, as well as our economic, social and cultural rights. In Australia, though, our domestic protection is patchy at best. And this is because for international human rights principles and norms to be reflected in Australia, they need to be implemented by way of domestic legislation. And Australia hasn't done this in a consistent or coherent way. So you might be surprised to know that there are some fundamental human rights that aren't adequately protected in our legislative framework. For example, the right to freedom from arbitrary detention. And this is why we see refugees and asylum seekers detained for coming up to 10 years without any accountability. Right to privacy is another one, right to religion, right to freedom of assembly. I also want us to recognise that Australia is the only Western liberal democracy without a federal charter of human rights or a bill of human rights that comprehensively protects and respects all those basic human rights. So that's an extraordinary gap in the protection of human rights in Australia. In terms of what's at stake, with emerging and new technologies, we know the tremendous potential and power this has to improve our everyday rights. But of course, with these tremendous opportunities comes great risk. And it's so important that we are cognizant of these risks, particularly risks to the right to privacy, the right to freedom of association, the right to equality, and non-discrimination.
Yeah, thank you so much for that. Following on, what are the responsibilities of business under the UN guiding principles on respect to human rights?
So when we think of human rights, we often think about the state's obligations to protect its citizens. However, businesses also have a responsibility to respect human rights. And there is the United Nations Guiding Principles on Business and Human Rights, which provides a framework for businesses to prevent and address its adverse human impacts of business activity. So these guiding principles set out that businesses must respect human rights and they must address any negative impacts through remediation. And along with these international principles and norms about business and human rights, we've seen over the last 10 years a real shift in community, customer, and shareholder expectations of businesses to act ethically and consistently with human rights. It's the social license to operate has never been more critical.
Thank you very much, very insightful. I'd like to follow up with a question for Kate. So some of the investigative work that you've done with Choice as a consumer data advocate has actually exposed a lot of very serious concerns about the abuse of facial recognition technology. What are some examples of businesses breaching privacy in order to profit?
So many. Where would I start? Maybe I'll talk about facial recognition first, because that's been a topic that's come up this morning. So probably the work that my team's best known for at Choice is our work into facial recognition technology being used in retail, and we've had a few mentions of that this morning. Might have been last year. It feels like I spent 10 years of my life talking about facial recognition technology, but it's actually been about 18 months. About 18 months ago, Choice had actually a sister-in-law of one of our staff members went to Kmart and tried to return something, and the staff member at the service there said, "Oh, I just need to check our facial recognition system to see that you didn't steal it." And they went, "Excuse me, what?" I had no idea that facial recognition was being used, and in fact went and told her brother who worked at Choice, and they had no idea and I had no idea. So we just decided to find out, and from that investigation we found that two of Australia's biggest retailers, Bunnings and Kmart, were using a system of facial recognition. And I think importantly, when we think about the context of commercial use and what this might mean in the context of the geopolitical conversations and political conversations we've been having this morning, is that they were storing a database of people that they deemed undesirable. So what this has exposed is that there are companies who are now determining who are the right kind of people to come into their stores and who aren't, with no oversight. There's no information about how you get on this database, how long you stay on the database for, how you get off the database, if this is in fact accurate. And as the example of patron scan that Manal pointed out earlier, this is then sometimes being shared across businesses, so sometimes hundreds of businesses. So patron scan is shared. It's quite widely used, for example, in Fortitude Valley in Brisbane. The whole precinct shares the data across all of the venues in that precinct. Bunnings and Kmart never answered our questions about how widely they were sharing that information. I'm lucky, to be able to say that following that investigation, there was a huge kind of public outcry. This was really the first kind of time that I think Australians realised that there were these really large commercial businesses using facial recognition in this way. And just completely unbeknownst to people, I think one of the reasons it was so shocking, and also shocking for me, is that the photograph that I took that we put in our investigation, in our story, that kind of went up and had this tiny little sign at the entrance that said, in tiny print down the bottom, and we're using facial recognition technology. Clearly no one. That was my local Kmart. That was the Kmart that I go to all of the time with my kids to do our, Christmas shopping and the like. So it was shocking even for me as an advocate who works in data privacy to see that this had become kind of widespread and normalised to the point where no one even realised. Actually, all of us have probably been to a Bunnings and Kmart. This wasn't some kind of niche technology that was being used in some far off land. This was something kind of very mundane and common. So I'm happy to say that following all of that public outcry, Bunnings and Kmart have paused their use. We made a complaint to the privacy regulator here in Australia. But the biggest problem at the moment, we're still waiting for that complaint to be resolved, for the investigation still to be done, which maybe I'll speak later about the difficulties of regulating privacy, and to that extent the human right of privacy in this country is very difficult. But there's no actual law banning the use of facial recognition, either for governments or for commercial enterprises in Australia. And that's one of the reasons why I've taken up a fellowship with Human Technology Institute, and Sophie, my colleague, is here today, is that they are working very hard to propose a law that would regulate the use of facial recognition in Australia. But I think it's really important to treat this in the context of currently there is no law that is preventing these businesses from doing that. There is aspects of privacy law that relates to the collection of biometric information, and that was the basis of our complaint. The other thing I want to just call out from our work at Choice is just how prevalent this idea of private and commercially operated databases that determine people's trustworthiness. So I think most people think that social scoring is something that happens in China. for example. But hands up here if you have ever booked or stayed on an apartment or a venue from Airbnb. Who here's used Airbnb? Yeah. So in 2017, Airbnb bought a company called Truly. Now, Truly didn't have all that much going for it except for a patent. So they had a patent that was listed in the US and listed in China and also in the European market. And this patent is essentially a social scoring mechanism. So essentially what the patent does, it's a technology that scrapes information from all publicly available data sources across the internet. So for example, when you sign up and you verify your identity with Airbnb, it goes, oh, Kate Bauer, and then it goes and looks everywhere it can find for all mentions of Kate Bauer, and the algorithm described in this patent then crunches all of those numbers and comes up with what they say is a trustworthiness score. So the idea, I think, of a trustworthiness score is kind of junk science, but this is, in fact, what Airbnb bought. So they've renewed that patent multiple times since purchasing the company in 2017. They've never disclosed if, in fact, they are using it. But what we were able to find out is that in Australia, people had started getting removed from the platform by getting an email from Airbnb's trust and safety team that says, we've identified something in your account and you are now removed from the platform. When people then tried to contact Airbnb and say, I don't think this is right, can you tell me what's going on? What's the reason? Airbnb investigates, comes back with another email and says, oh, we've investigated, we've decided we were right, and sorry. So no explanation of what data that they use, no opportunity for that person to correct the record if in fact they got the names wrong, if it was a very common name. And we've seen the Choice investigation also uncovered that this was particularly targeting people who were involved in legal sex work. So sex work is legal in many jurisdictions in Australia, but it's obviously not legal in many places around the world. And it appeared that the Airbnb algorithm was deliberately picking up people. So for example, if they went and searched Kate Bauer, if I then say had an OnlyFans account, or if I had a legal sex work business that was in my name as a website, they would find that information and then it would come into the algorithm and then be deemed as untrustworthy, and then you can be removed from the platform. So like obviously not being able to go on holiday with Airbnb is no great loss. There are other options. Maybe you don't even get to go on holiday. I certainly haven't been on one in a while. But I think we can see here the dangers of commercial operation of these databases that are essentially doing a form of social scoring with no transparency, no form of redress, no way for consumers to act back, and no government oversight. Again, we made a complaint to the privacy regulator here in Australia. Unfortunately, that complaint has not been picked up, as far as we know. And so basically, that's it. That's the end of the line. The only thing we can do now is say, I can come to places like this and tell the story of what that's doing. And that's just one example, I think. There could be many more businesses who are operating in that same way without our knowledge.
I have so much to say on that, and I'll chime in a bit, and I'm sure Simon and everyone else has something to say as well. But yeah, very Black Mirror dystopian. So I guess I'd like to talk about how it's a well-known and heavily researched issue of racial bias when it comes to facial recognition. And it actually comes down to hardware limitations. It's not even the software. And so the way this technology essentially analyzes the ones and zeros is limited by the fact that harkening back all the way to the Kodak era when we were developing photo cameras for the first time, it was innovation that was essentially designed around like the Caucasian or the light-skinned people, and so it really struggled with different complexions and in interpreting that information from a mechanical way. And so we look at video technology today; it still struggles with that. And so the AI software that's sitting on top of that, and often they're deployed on quite low technology cameras, they struggle to interpret that information. And so you're getting that bias and the racialization that's within society reflected back in those technologies. And there's publications that are coming out of Harvard, MIT, Berkeley, Stanford, world-leading institutes that corroborate this information. So we could be looking at a future where a lot of people, we get that social enforcement. Like as an Indigenous person, I've experienced that a number of times, being followed around of suspicion. With that being backed up by AI, it can create, a hostile and enormously prejudiced environment where we start to see segregation more at play, and that's something I'm deeply concerned about. And it's been deployed in the public space, all public spaces, and I think that speaks to a quite dark future for us. And yeah, I'd also like to follow up on blocking individuals from platforms ubiquitously. So a lot of tech companies actually share that information, and it goes far deeper than you realize. So it's not just Airbnb saying, oh, we've used these APIs, so these different data sources to determine that you're not really worthy of doing business with us. We consider you a risk. They can also share that information. And for example, if you for whatever reason get blocked or banned on Tinder, they're owned by a big parent company. And how they do that, they conduct that blocking is they use your IMEI, which is a hardware identifier in your phone. And any accounts that you've logged in to that from your phone, they have a bit of a fingerprint of that, and so they can go, okay, you're associated with X amount of email addresses, and this is where you work, and so they have a lot more information. They can get everything right down. You hand over your ID, but you don't really realize you're handing over a fingerprint of all of your online activities, accounts, and everything else. And so you get banned on one platform, you might get banned on many, you might get a bit of a cumulative risk score that works against you, and again, you end up disenfranchised from a lot of the freedoms that you would assume and presume to currently enjoy. Like, maybe that could impact everything from your insurance and online shopping. We don't really have much regulation in that space, medical healthcare, that it can really infringe in all spaces. So yeah, I'll go to our next question, unless anyone wants to also chime in on that. I'm sure we all have some pretty deep opinions. So this next one's for Simon. So disinformation and misinformation campaigns represent a threat to countries' national security, democratic resilience, but also pose a threat to the freedom of the press and media manipulation. So note, Labour recently announced they're going to overhaul the misinformation bill after objections over freedom of speech. So that will delay introducing the legislation until 2024. And so there are vested interests to maintain the status quo of allowing disinfo and misinfo to be conducted such that nation states can undertake their own campaigns against hostile nations or political parties. It's information warfare, and it's highly effectual, as we know, with Brexit and what's happening in the US, and more recently in our own backyard with the referendum, which was very painful for Indigenous people. So Simon, what are your thoughts on striking the balance between mass surveillance on technology platforms and combating information warfare?
Yeah, that's a really good question, and I like to draw on a paper that I published recently, pretty much talking about how Wikipedia needs to have this delicate balancing act between having its collective intelligence and improving the information on this open editing source platform, but also against mass surveillance, which the NSA has been doing. So I guess I'll talk more about that. So pretty much to start off, has anyone here used Wikipedia? And perhaps has edited on Wikipedia, perhaps? Yeah, a few people here. Yeah, so it's pretty much an open editing platform, and users, me and you, can edit on Wikipedia. You just create an account and you just create your edits. The only information that's being recorded is your IP address, and that has a lot of implications, which I'll talk about later. But pretty much Wikipedia is used by everyone. There's millions of edits every day. And essentially, it's used in tertiary institutions, universities, and it's also used as one of the primary sources. And the reason why it's used as a primary source, and it's very encouraged to do so, is because of something called collective intelligence, essentially asserting that the increase of information will eventually become accurate over time when you have this large amount of contributors, also called as Linus's law. And there's been many cases of also Wikipedia being able to be a platform that not only provides information to the public and also kind of gets rid of some misinformation or disinformation, but also creates these sort of campaigns available. And there was this anti-SOPA campaign, the Anti-Stop Online Piracy Act, against the US. And as a result of that campaign, a lot of websites, including Wikipedia, kind of blacked out the pages for that day. And as a result of that, actually stopped that bill from passing. So it shows that Wikipedia has that potential to not only be that platform that everyone uses to look at encyclopedia, but also to have this mass movement available. And I guess to the other aspect is talking about the PRISM technology that actually Manal mentioned earlier with the Edward Snowden, the NSA whistleblower, where there was some leaks available of upstream intelligence, which shows that Wikipedia is one of the platforms that actually has been monitored, including with Google, Twitter, etc., and all these other digital platforms available, which I might actually talk about later if I have time. And essentially, there's something that as a concept called chilling effects. And as a result of that, it's like, once you have these increase of like state movements or like increased knowledge of like mass surveillance, it actually kind of chills or like freezes people from actually contributing to these online platforms. So it kind of chilled these Wikipedia users. And actually it shows like, as a result of like Edward Snowden's leaks and all of this information that came out, there was actually less edits on Wikipedia that were going towards those controversial articles that perhaps could be like the Tiananmen Square massacre, for example. And I guess for Wikipedia's perspective, it really wants to create that balance of like trying to improve the information on the internet, try to like enhance these like these digital platforms and create that open space for people to like contribute. But on the other hand, it kind of has to like counterbalance these NSA groups trying to get into the IP address of these like users. And also, as a side note, you actually can't use technologies like Tor and also VPNs to make edits on Wikipedia. So Wikipedia kind of has this balancing act. And I guess my proposed solution is actually trying to understand like the socio-cultural side of things. And I think it does play a part in it. For example, Wikipedia is not only available in English language, but also in other languages too, such as in Chinese. And it shows that because there is some kind of like group mentality or willingness to like work together to, I guess, provide these accurate informations on like the Tiananmen Square massacre and all these other controversial articles, that they're actually kind of not swayed by these chilling effects. And as a result, I think that doing further research on this field might actually be helpful. And I also think that I also did a submission to the UN lately on enhancing information integrity on digital platforms, which is trying to combating like fake news or like trying to mitigate the use of misinformation, disinformation online. And one of the key things that I talk about is like having this sort of like whistleblower protection sort of framework or assessment. And as a result of that, it actually kind of enforces or bolsters this sort of like legal protection that we don't really have in Australia and perhaps some places around the world or perhaps in these like nation states that might be more like encroaching on its citizens. And that could potentially improve, I guess, some sort of systems in place in Wikipedia and these contributors and hopefully creating this overall like flow-on effect.
Yeah, thank you for that. That actually reminds me, a good friend of mine recently told me he was actually the target of one of the largest sock puppet attacks known in Wikipedia history at the time. So a sock puppet is essentially a fake account piloted by either a bot or by a campaign, by a nation state or criminal org. And so he was actually awarded the Weifel Bat by Wikipedia for holding his own and remaining civil amongst the barrage of verbal abuse. And that was prior to large language models, but the suspicion was they're actually using early language models to create these personas. And they were using the anonymity of Wikipedia to create new sock puppet accounts. Why can't I say that word? And they would pop up, and then another one would be blocked, and it was just like a hydra. Each time you slayed one head, two would pop up, and so yeah, it's a hard balance to strike, and it's a really important discussion. So I'll ask one more question, and then we'll open it up to the audience to ask questions. So this is for the panel. What are some of the major flaws for our existing privacy regulations?
Do you want me to start? Yeah. So the Privacy Act in Australia has been pretty much unchanged, so a few minor tweaks since it came into being in 1988. And I think anyone can realise that our world has changed significantly in terms of what privacy might mean and in terms of the amount of data that can be collected. So because of that, it has a lot of holes in it. It's basically Swiss cheese, maybe even a fishing net at this point. It is not really catching most of what it needs to catch. So I would say, so to put that in context, it has been under review. There was a 2-year review done by the Attorney General's Department, which then they released a report earlier this year in March, and the government has just announced their response to this report. I do have to say, on the whole, the response has been fairly positive. The government has committed, agreed in principle to most of the suggestions. But I'll just highlight maybe 2 or 3 that I think are like really critically important that could really lift the protection of privacy in Australia. One is the definition of privacy, a definition of personal information. So at the moment, because the Act was created in the 80s, when really all you were worrying about was someone getting your name and address and sending you some unwanted direct marketing, it's quite limited. So at the moment, it's personal information about a person, and what the proposal is to change that to information that relates to a person. So that seems like a really tiny tweak, but what it actually means is it could encapsulate all of the device identifiers, the IMEI, all of the IP address, all of the things that allow you to identify somebody and act on them in the digital world and in the physical world without actually knowing their name. So that's a really critically important change that means lots and lots of practices that are currently happening, particularly around data broking and around targeted advertising and digital marketing, are now falling outside the scope of the Privacy Act because they're using only these device identifiers and deliberately refuse to know people's names in the same way with Wikipedia. Then they don't have to comply with privacy law because they don't identify people by their name. So that's one really critical change that absolutely must happen in order for our Privacy Act to be fit for the digital age. The second one is the introduction of a fair and reasonable use test. So at the moment, we've got what we call the APPs, the Australian Privacy Principles. They do set the standard and provide some guidance from the privacy regulator, but the concept of introducing a fair and reasonable use test is like a principles-based idea. So it's supposed to be a bit technology neutral, so to give us some protection so that when we think about these new technologies coming into the future, the onus will then be on the business instead of the individual. So instead of you having to read through a very long privacy policy and consent, which none of us do, like, let's admit it, even people who work in privacy really struggle to read the whole privacy policy and hit that consent button. We all just go around clicking around. Instead, the onus will be on the business to make sure that the way they're using your personal information is fair and reasonable. And that seems super basic. Like, that just seems like something that we should already have. I think if you spoke to most people what they thought our privacy law did, that's probably it, right? Like, that, to make sure that people who have your information are using it fairly and they're not trying to use it to exploit you or manipulate or deceive you. So that's really important. And I'll just say one more, which is around the use of high-risk technology. So as I mentioned, at the moment, there is no law regulating the use of facial recognition. One of the proposals that has been agreed to in principle is to put in a human rights impact assessment or to put in a higher level of privacy impact assessment for high privacy risk technologies, of which facial recognition would be one. So those are just 3 of the responses that the government has agreed to in principle. And I say in principle multiple times because at the moment there's still not a firm plan of how and when this is happening. We're likely to see some legislation next year, early next year. But it's really critically important that anybody who cares about these issues starts talking to family and friends and really makes sure to the government that their voices are heard and that this is something that has to happen. There is a lot of business lobbyists right now in Canberra. There's a lot of people from big tech. There's a lot of people, the Business Council directly from organisations themselves who are working very hard every day in Canberra to make sure that these laws don't get passed, including the big media companies. So now is really the time for individuals to make their voice heard.
Yeah, thank you very much. Yeah, I could chime in on how powerful all of this data is, your IP address, even a singular email. So, working from the cybersecurity world, there's tools that we refer under the spectrum of open source intelligence tools. You might have heard of them. So we've got like this thing called Baskador, and there's a few others like Shodan. And all you need is a single email address, and you can get kind of like a fingerprint of that entire person's life, and it's all free, easily available. Any single one of you can do it, and without paying a subscription fee. And so we're handing over that data regularly to just conduct our business. Might even to check in at a restaurant and order via QR code, or real estate agencies. And there's so many evasions as well for existing privacy regulation. Under the Small Business Act, that's something we discussed earlier. So yeah, it's a bit of Wild West out there. I think a lot of people are feeling quite disaffected by that and powerless. And I think that's why we need to urge for change. So yeah, I'll open up to the audience if anyone wants to ask any questions.
Thank you. I have a question for Dr. Bauer about privacy law. In your own view, the privacy reform report, which was open for public consultation, received a few hundred inputs from different parties, including the big tech. You see the report's 80 pages versus academia and other privacy advocacy group. In your view, how much you think that the government has took that feedback into consideration? Number one. The other question, what personally you think about noting the political exemption reforms? None of them was agreed in principle. Thank you.
There's two questions there. So one is, I guess, about how loud are privacy advocates' voices and how much are they being taken into consideration. Look, the good news is the reason why I feel most hopeful about privacy reform at this particular moment is because we actually have an Attorney General who cares personally about privacy, which is quite rare. Attorney Generals have a lot on their plate, and indeed this one does have, following the referendum, but whistleblower protections, like the Anti-Corruption Commission, etc., like a lot. So privacy often tumbles down the list. So I feel quite hopeful that Dreyfus is personally committed to privacy reform. That doesn't mean that it's simple. Like having the Attorney General personally committed, as I said, there are many, many lobbyists in Canberra every day speaking to every minister, speaking to every crossbencher, speaking to everyone in the opposition, speaking. So it's not enough just to have the Attorney General. I think we can't be disheartened. I think if I look particularly at Choice's work, and Choice has been around for 60 years and is entirely funded by members who care passionately about consumer rights, it went up against the big banks during the Royal Commission, had been working on issues that had been speaking to people who had been harmed by banks and been harmed by the financial services sector, worked hard to get that Royal Commission up, and has then seen since then a huge raft of reforms to the financial services sector. And you would think going up against the banks are like the biggest kind of opponents that you can do. So the lesson I take from that is that if you're on the right side, you can win, right? So I think that even though there is probably there was 310, I think, submissions, so probably 290 of those were from industry, and the rest were from advocates. But I think if you're on the right side, you can win. There's nothing more compelling than the truth. And the truth is that privacy is a human right, and all of us deserve that. So I think, if that's the message that you're selling, then you can win. The second question, which I've now forgotten, was about political exemption. Look, okay, so at the moment there are three major exemptions to our Privacy Act. There's a journalism exemption, there's a small business exemption, and there's a politician's exemption. So I don't think any of us working in privacy ever thought that the political exemption was actually on the table for reform. It's just not possible. Like when your parliamentary system is making rules about itself, I don't even think, how do I feel about it? It's bullshit. You know what I mean? Like, why should politicians have to have different rules than everybody else?
Just like expecting Turkeys to vote for Thanksgiving.
Exactly, that's right. It's never going to happen. That's just the reality. I think if we can get some of these other reforms in, it's a big step forward, but it's not the full picture. Pleasingly, we have seen a green principle for the removal of the small business exemption, and I think Candice mentioned earlier rental applications. Choice also did some work on rent tech, and recently just gave a shonky to the rent tech sector, which is the third-party platforms that are collecting all of our rental information. But a shocking fact is that 2/3 of real estate agencies are not currently covered by the Privacy Act. And you consider if anyone who has had to engage with a rental application recently, like they're taking photographs of your birth certificate, your driver's license, they've got all your financial information, they have your name, your car, your pets, your children, all of this information, and yet they currently, 2/3 of those agencies are not under any obligation legally to protect that information, so you're just trusting them. They may have no cybersecurity in place. You don't know. But as a renter, you have no choice, particularly in today's current rental market. You just have to hand it over. You have to do what they say because you need somewhere to live. So I think that is really critically important, that we get rid of the small business exemption. And pleasingly, we've seen the government agree to that in principle. But again, this is why it's so important that we do this now.
Yeah.
Thank you. What amazing. I'm learning a lot of things. And I thought I'm the guru. Prabha, a question to you. How can we make the Australian government have human rights codified in the federal law? How can we do that? As I'm a citizen, I want to do that. How can I? And a question to you. You're a humanitarian. How did technology was used for humanitarian crisis? I think that would be interesting.
Well, about 12 years ago, there was a big inquiry into whether Australia should have a Federal Human Rights Act. And it was an independent panel that was put together, and they travelled around the country and held countless stakeholder consultations, undertook research, and produced a report that did recommend that Australia should have a Human Rights Act. And quite shockingly, actually, the Labor government refused to accept that recommendation, which really put us back, I think, about 2 decades. The Australian Human Rights Commission over the past 3 years have re-agitated this campaign, and they've conducted a free and equal inquiry, and also now put forward a roadmap for a Human Rights Act, which is something that the Attorney General, who is very interested in privacy, is also, I understand, supportive of a Human Rights Act. So definitely watch this space, and when that starts to get traction, I think it's really up to civil society to get behind that campaign and fight strongly. We had so I was part of a steering committee that was leading work 12 years ago on a National Human Rights Act campaign, and all our polling at that time showed that there was a majority of the population, when they knew the limited rights that are actually protected in our legislative framework, were supportive of a Human Rights Act.
Another question. You mentioned when you were part of the Manaus Island investigation, you faced huge smearing campaign in the media, the Human Rights Commission. Can you tell us more about this and how social media and digital media were actually, because this is like from the trenches, people were faced here in Australia with disinformation campaign. Can you tell us more about this?
Yeah, that was back in 2013, the Australian Human Rights Commission announced a national inquiry into children in detention. Now, the government at the time took absolute offence to this inquiry. They labelled it as politically biased inquiry because it was conducted 6 months after the coalition came in and not when the Labor government came in. Now, the reasoning for that was under the Labor government, there were higher numbers of children in detention. It was sitting around 2,000, but they were steadily being released into the community. Whereas under the coalition government, what we found, we gave them about 6 months to see what they were going to do, and we found while the numbers were lower, it was around, I think, 1,500 children, they weren't moving. The minister wasn't releasing them into the community, and that's why we announced a national inquiry. Now, as mentioned, the government really took umbrage to this, and then the right-winged media, the Murdoch press, started to really fuel the fire. And we were on the front cover of the paper a countless number of times, and they really waged a war against the Human Rights Commission and tried to undermine the inquiry, but we stood firm. We got through the inquiry. It is an extraordinary documentation now of the mental health and the physical and the developmental impacts of indefinite detention on children. And shortly after that report was released, almost all of the children were released into detention. But we talk about misinformation, disinformation, and there's outright lies. And one really clear example I want to illustrate. Politicians often talk about asylum seekers and refugees, asylum seekers, being illegal. Now, this absolute lie is then fueled by the media, and what you see is a campaign of fear-mongering and real, I think it's inciting hatred against refugees. And the fact is, asylum seekers are not illegal. To the contrary, they have an international law right that Australia recognises because they've signed up to the 1967 Refugees Convention to seek asylum from persecution. So it is blatantly incorrect, but the way that lie has spread like wildfire in the community is just, it's phenomenal, and it's really sad.
Yeah, I guess to answer Manal's question, which earlier, I guess I'll be kind of talking about the intersection between conflict zones and also like data. And I think I guess I'll talk about like a more personal story. So I spent some time in Ukraine last year during the war, and like, you know, from the 24th of February 2022, it kind of, you know, reignited again as a result of like the conflict between Russia and Ukraine, obviously. And essentially what the Ukrainian government has done over the past year or so is kind of create this sort of like government digital uplift. So it's kind of like improving its technology platforms as a result of obviously the hacking by the Russian Federation. And since 24th February, they were sitting pretty much together, the government ministers, and they were talking about like concepts of data, but to be more in particular, like data localization. And in terms of like, where should we have our data? Like, should we have backups, or like where should we put this, because they could be prone to anything. And I do have a different perspective on what they have done. But essentially, they decided to kind of offshore kind of their government backup data and also some personal information, like registry, land records, to the Amazon Web Services. So they kind of had this agreement in place, and it was kind of like moving that physical location towards to Poland or some other location, and pretty much just moving up to the AWS centers. And I guess I would like to talk about this because I think data localization is a very important concept, and it kind of relates to also like data sovereignty. So data localization is pretty much where you physically store that data, right? Data sovereignty is the kind of legal or regulatory aspects, implications that you have to consider as a result of that data and where it's pretty much stored. And I do think there's actually benefits to data localization. So instead of having these like cloud storage providers and trying to like use these services, I think it's good to also have that, especially in a conflict zone environment, to have it physically in your own country. And there's many benefits to that. I think just to list a few, I think the first one is just you're reducing foreign espionage capabilities. Because yes, even though you have missiles coming your ways and also Shahed drones or kamikaze drones, which I've witnessed myself in Ukraine, like it's still many benefits to kind of removing that kind of like human-to-human interaction. And that's really the core of like human intelligence and intelligence in general, just having that like kind of human and personal effect on someone to be able to like access the information, whatever objective that they have, which in this case would be the data. So removing that foreign espionage capability is one of the benefits of pretty much like having your data like onshore. And I think another benefit is being able to access that data from a minute-to-minute basis. You know, the intelligence cycle runs very quickly from like seconds to minutes. And I think being able to access that data, especially when trying to figure out perhaps like what type of infrastructure is being attacked, is very important. So yeah, I think those two are quite beneficial. And I think like on a side note, I think just talking about like regulation in general, I think there's kind of like three models that are kind of approaching. And it's kind of like the US model, the European Union model, and also the Chinese model. The US model being like a markets-driven model. The Chinese model being sort of like a straight state-driven model, where like kind of like where you operate in China, you kind of have to cooperate with the Chinese government to some extent. And you also have the EU-driven model, which is a rights-driven or kind of human rights-driven model. And people refer to GDPR as like kind of like a privacy reform or act, but in reality, it's actually a data protection one. So it's kind of different, and it covers and catches all. And I think that's very relevant in today's context, because when considering like data sovereignty and data localization, it's like as a business or as a government, it's like where do you choose to store your data? If you want to do business with China, you might have to have like a privacy officer there. You might have to do relations there. And the recent Chinese personal and information protection law, the people, right, kind of has this extraterritorial effect, right? If you're doing business in Australia that perhaps might relate to like Chinese students, like, and something goes on, like the Chinese government will come over and see like what's going on. You have to talk to me about it. So I think there's really vast implications that's going on, and that's result in like also conflict zones, and also when dealing with like, I guess, foreign state actors too.
Hi, thank you for your insights. My name is Nakshatra. I'm a criminologist and a cyber safety researcher. I'm also the co-founder of Iris, and we're looking to revolutionize online safety. One of the big things that I believe is everyone should have access to a safe online experience, and that is a human right. I'd love to get your comments on how Australia is being praised as this thought leader and they're stewards in this space, but it's actually just because they're doing it first and embedding it in legislation, and not really the words don't match the actions. I'd love to get your thoughts on that.
Who wants to start? Maybe I'll start. Look, that's a really interesting question. I think in some ways Australia, like often when I speak to advocates from overseas, they'll be like, oh my gosh, we're all looking at what's happening in Australia, it's so fantastic. And then we'll say things like, well, do you know we don't have a Human Rights Act? Do you know that our privacy law is from the 1980s? So sometimes it's just a matter of perception. So I think certainly the creation of an e-safety commissioner and the Online Safety Act are seen as world leading in some ways, but it is a much more complex picture than that. The other thing I would say, which I think relates to what Simon was saying here about the complexities of data localization and the need for cyber secure, in terms of geopolitical turmoil and conflict and the complexities of that, it's kind of the same with online safety. That so many of the things that we think make people more safe, sometimes they are implemented then make people less safe. So we saw here, for example, here we've seen debates around age verification, which fortunately the government has decided to ditch. But that was going to introduce a lot of issues, like how do you verify people's age? Well, you need to collect information about them, and particularly information about children, and then suddenly you're storing birth dates and names of people about children. So you can see the complexity of that. And the example that I mentioned earlier around sex workers being removed from the platform, a lot of the reasons why sex workers are particularly deplatformed and persecuted online is actually about other laws that are intended to protect safety of children. So particularly in the United States, they've got these quite draconian laws called HOSTA and SESTA, which are about the removal of child exploitation material and sexual abuse material online. But often the way that they get implemented is in ways that then have flow-on effects. We've seen a constant debate about encryption and whether or not we need to protect encryption of messaging because I think Meredith Whitaker from Signal has been really, really outspoken on this issue that like you can't create a backdoor for governments without creating a backdoor for cyber criminals. So I think it's important to understand that these are really, really, really complex issues. So just creating one online safety act could have flow-on effects for a whole range of other different parts of the system that could make other particular marginalised groups of people less safe or could open the door for criminals. So I think it's really important we think about the integrity, the infrastructure, and this point about data localisation. One thing that we haven't had a chance to kind of bring up is just the huge economic power of only having a handful of companies being responsible for our data centres and cloud systems. So AWS controls 40% of the world's data centres. So you want to know how they get an open door into every government in the world? It's because they control 40% of what's online, right? They can flick that switch anytime they want. They can bring down entire infrastructure systems. They can bring down ports. They could bring down governments with that level of control. So I think the story is more complex than that. So is Australia a world leader in some ways? Yes, but it can't just be in one lane. Like we have to treat it more holistically.
Yeah, I just want to chime in slightly. So what I find really interesting about the Anti-Encryption Act is, there's actually a huge black market and also intelligence marketplace for the purchase of backdoors and 0 days. It's extremely expensive. And I was just like, it's essentially the government being like, we just don't want to pony up the cash. You want to have, ultimate access and insight into all these systems and just have, supreme entitlement to it and maybe not have to pony up the, $500,000 to have access to, whatever device or whatever system they need.
Protection of biometric data as, we grow these databases, because obviously, we can change a key, but we can't, change our faces. And as you say, some of this data's already been collected and utilised and stored in databases, under no level of protection. So that's kind of the first question. And the second part of it is related, and, in terms of something I make, if you like, if I add another factor of authentication, as we start to integrate and use large language models, and our behavioural use, etc., becomes a biometric footprint that we currently can't take out of a language model because there's no right to be forgotten in a large language model at the moment. How do we protect that now before it's too late?
I'm not even going to attempt to answer your technical question, but you're part of Accenture, so something, got a final comment for businesses to be aware of. And that is research that shows that emerging and new technologies negatively impact some groups more than others. So the research shows that groups that already suffer discrimination and social and economic disadvantage have a higher risk of being negatively impacted by these technologies. On the flip side, groups that do experience better social and economic status are positively impacted on those technologies. So just to be really careful where those social inequalities are being fed through algorithms, resulting in exacerbating those inequalities when they are implemented.
I guess I can answer your second question. Sorry.
Yeah, you go.
I guess I can answer your second question. I think we should have something called an algorithmic impact assessment in place. And I think I kind of see this as an analogy to like the current privacy impact assessment that we have. It's kind of like a uniform, well, hopefully uniform process, and fine encoded within the legislation. And recently the EU is currently debating about the AI Act, right? So I think having these sort of like processes where we kind of like trying to enshrine them in legislation will help. But I guess it always comes down to the question of like, which comes first, like the legislation or really like the improvement of technology that kind of outpaces these legislation. So I think there should be some kind of like working group or international discussion about like how to move forward, as we probably have seen with like ChatGPT and the other players out there. But I do think like we should have some sort of like AI, and I think that would help like drive the message and kind of like create this uniform like sort of processes and sort of like assessment, and hopefully it's been applied internationally.
And that looks like it's time for our panel. Thanks so much for having us, and we'll hand back over.